Welcome to the Rocky Mountain MS Center's Empower webinar series. This series is designed to give people with MS information to empower them to make the best choices for their lifelong brain health. I would like to thank the pharmaceutical companies who have provided support for this program. Thank you to Genentech, Novartis, and Sanofi Genzyme. Today, we will be discussing how to stay in the workforce and how to protect yourself in the event that you can no longer do so. This presentation features Tom Stewart, a disability attorney and physician assistant. Tom Stewart has worked with the Rocky Mountain MS Center for more than 2 decades, providing medical care, education, and legal support for individuals navigating and applying for Social Security disability insurance or private disability insurance. Tom studied as an undergraduate at the University of Notre Dame and studied law at Boston College Law School. After clerking for the New Jersey Supreme Court, he attended physician assistant school at the University of Colorado, where he received his master's. This webinar features a lot of really important information. If you missed something on a slide and want to hear it again, we will be archiving this webinar on our website, mscenter.org, so that you can replay it at any time. We'll reserve time at the end to answer questions from the audience. You can submit questions at any time by typing them into the question window on your screen. We will answer as many questions as time allows. And with that, I'll turn it over to Tom.
Thank you, Kelsey. I was going to introduce myself, but I can't do a better job, so thank you. So this talk is intended for people who are working with MS or other chronic progressive diseases for that matter, to highlight some of the tools that may allow you to stay in the workforce and to protect you if you become unable to do so. But before beginning, I want to address the anxiety that I feel when talking about this material. I want to avoid the implication that people with MS are necessarily going to lose the ability to work. So here's the way I feel about it. It's increasingly clear that with good medical care, many people with MS will maintain normal or near normal function for their entire lives. But it is sobering to know that approximately 1 in 4 20-year-olds will lose the ability to work prior to retirement age, at least according to the Social Security Administration. And that includes people without any diagnosis whatsoever. So I think it's a good idea for everyone to know how to protect themselves should they lose some function or the ability to work entirely, and to take whatever steps make sense to increase that protection. So with that, I'm going to try to toggle over to my PowerPoint. So there are I'm going to organize this talk into basically 4 subtopics. The FMLA, the Family Medical Leave Act, the Americans with Disability Act, ERISA, which describes the protections that you have from benefits provided by your employer. So the private disability benefits is what I'll talk about there, obtained through an employer, which is mostly what happens with people who have a diagnosis like MS, because it's not, private disability benefits would be very difficult or maybe impossible to obtain outside of that situation. And then finally, I'll talk about the Social Security disability insurance, kind of the alphabet soup of ways to protect yourself. So first, we'll talk about the Family Medical Leave Act, which is federal law. This applies to public agencies, public schools, and large private employers. In general, employers with 50 or more employees. And it protects some people, including people with MS, from losing their jobs due to high absenteeism related to medical care and other reasons too, such as to care for a child. But for our purposes, that's the issue here. And so the basic protection is written here, provides eligible employees unpaid. That's critical. So you don't have to get paid during your leave. Protected leave, I've bolded that because that's the critical piece, which means that your job is protected if you use the FMLA to cover you while you're out, to provide care for themselves and close family members. So it's also an important law for caregivers. And in addition to having a protected job, you get continued insurance And you may have to pay the portion of your insurance that you pay out of your paycheck while you're out, but the employer will keep paying the employer's piece. And it provides up to 12 work weeks of leave in a 12-month period. I said for one of 4 reasons. And again, the main one here is the top one, a health condition that makes the employee unable to perform the essential functions of his or her job. And so there would have to be a certification by a healthcare provider, and it would contain certain elements, including the healthcare provider's contact information, the date that the health condition began, the duration of the condition, and then whether the employee is unable to work and the likely frequency and duration of the inability. And I'll try to give an example or a few examples of that at a later slide. And so not all employees are, not all employees are covered. You must have worked for a total of 1,250 hours during the 12 months immediately before the date the leave is to start. So you need to have been with an employee, a large employer. Sorry, you need to have been with a large employer for at least 12 months. And there's an exception that I've never come across for key employees where the absent would cause grievous financial hardship. And I think that's a pretty big word. So I think that explains why I don't hear it very often. So how might this be used for people with MS? So many people with MS are treated with a monthly infusion, Tysabri, and may from time to time need to go to physical therapy or psychotherapy. And with Tysabri alone, it would be, that would cause more than 1 absence per month. And if you ask a vocational expert, they will say that having more than one absence per month would not be tolerated in a competitive employment situation. So, but for the FMLA, somebody on Tysabri and who pursues physical therapy might be at risk for losing her job. So in that situation where there are a lot of appointments, it's good to use the protections of the FMLA. And then also might be helpful, of course, for an exacerbation. So if you have an exacerbation of MS, even with the good drugs that are available now, it still happens. And so someone might be out for 2 or 3 weeks and you would be protected in that situation. And then very interestingly, I think it can protect people who are at risk for intermittent leave. So as many people with MS, or maybe all of them will know, there are good and bad days. And you know, in some bad days, there's just not enough energy to even get out of bed. This intermittent leave protection from the FMLA can be critical. And then lastly, I think it can be useful for a pause. So sort of a stop action opportunity. So if somebody gets a performance improvement plan at work, or so their employer has noticed that their work is insufficient in some regard, and the employee feels like her job is at risk, it's really a good opportunity to talk with your clinician and seek some time off to do some research on what your disability options are, maybe get neuropsychological evaluations, maybe go to physical therapy. Maybe there is a solution with learning how to use a cane or something. So it's a time for additional symptom management, evaluations, and to sort through your options with a little time and some space to breathe. So what do you do if the FMLA rights are violated? Contact the Secretary of Labor's office. And it's also possible to file a lawsuit. I've never been involved in anything like that. I don't think it comes up very often. I could be wrong, but I've not heard of that. So this is becoming more important all the time, maybe even more will eclipse the FMLA in its importance, is the state paid family leave insurance. So some states have enacted legislation to create paid family leave insurance programs, which provide cash benefits to eligible workers. 9 states and the District of Columbia have enacted PFLI programs, or paid family medical leave programs. California, Massachusetts, New Jersey, New York, Rhode Island, Washington, District of Columbia, and 3 other states have enacted these policies, but have not implemented them, including, I think for our audience, Colorado. So we'll talk about that. And many other states have pending legislation. So I think this is even a more important legal protection for people with chronic medical conditions than the FMLA, as you'll see. So Colorado's paid medical leave program is also known as Proposition 118. It's been passed, but it's not effective until the year 2023. But you can sort of, I've made a graph here, or copied a graph from somewhere on one of the state's websites that describes some of the differences. And you can see that the main difference, of course, is that people can get paid for their time off here. There's a maximum of $1,100 a week, but that's relatively generous as compared with not getting paid. And to make things even a little more complex, I'm not going to talk about this too much. There's also, in 2021, there was a state mandated Sick Leave Act, which says that employees are entitled to up to 6 days of sick leave, paid sick leave. And they accrue it at this rate here, 1 hour paid sick leave for every 30 hours worked. And so there are other differences here. You can see there's a job protection here too, as with the FMLA. And the employer size is very important here. The FMLA doesn't apply to relatively small employers, but this will. So there's big changes coming in Colorado for 2023. Whoops. Okay, so we'll move on now and talk about the Americans with Disabilities Act. So there's again, this is federal law, and there are analogous state laws, but I will talk about the federal law here. So this applies to employers with at least 15 employees, and a person in this context, disabled, has a physical or mental impairment that impacts a major life activity, this is different from the definition of disability used by the Social Security Administration. But the main benefit here is that employers, provided by the ADA, is that employers must make reasonable accommodations to people who are qualified individuals with disabilities. So those words are not reasonable accommodation, are not defined, but I have some examples here. Making physical changes to render facilities accessible, say to wheelchairs, restructuring jobs, offering part-time or modified work schedules, offering to reassign people, or change physical space. So this is an amazing resource. This is probably, I don't know, maybe this is the most important thing to point out to this group, is just that this exists. So this is paid for by the Department of Labor, the Job Accommodation Network, or JAN. I tried this out today. There's live support, and I got very good answers right away to a question that I asked. So for very particular questions, I think going to the Job Accommodation Network about accommodations would be an excellent first step. So on their website, in addition to the live support, they have a lot of information organized very well. So you can look up by disease and look up multiple sclerosis, and you'll see some of the suggested accommodations here, like a flexible schedule, rest breaks, working remotely, or modified workspaces. And then if you you can even click further on to flexible schedule, and then it will explain more about that. So for example, employees who experience certain limitations may need a flexible schedule. Flexible schedules can also be used to have a period of mental rest in order to refocus and reorient. Examples would be adjusting starting and ending times of a workday, combining regularly scheduled breaks to create one extended break, or dividing large breaks into smaller segments, and allowing work to be completed during hours when the employee is most mentally alert. So those are great examples, but I think I'll talk about a harder case that recently came up, and as another example, because there's so many aspects to it. So in clinic, a patient was having trouble keeping up with her work as a manager. And another clinician before I saw her had suggested a 6-hour workday limit would help her stay in the workforce. And then she came on my schedule to further document this restriction. And there was just a lot to talk about that she hadn't really considered. So she was under the impression that she would be entitled to full pay. And I don't think that is the way that would have worked out. So she would have been, received a pro rata reduction in her salary. And at a 6-hour work week, she wouldn't have been entitled to benefits, including disability benefits. And in this particular instance, it seemed quite likely that that was ultimately the way this would play out. So it really would have been pretty disastrous for her to go down to a 6-hour a day shift and work 5 days a week, and then to finally need to go out on disability without any disability insurance anymore, private disability insurance. So what she decided to do was she decided to request that the limitation be changed to 7 hours per day, because she would keep her benefits and have that protection if she was unable to continue at that rate. And then there's one other kind of interesting wrinkle to that is that she has private disability benefits, and it's possible, depends on the plan, but it's possible that she might have sought partial disability benefits. So let's say she was working 7 hours a day. It might be that her disability plan would pay 60% of the 5 hours she wasn't going to work. So, I mean, it's all fact specific and depends on what the policy says, but there's a lot more to a reduced schedule than initially meets the eye, I think is what the main point of this slide. And you should probably talk with somebody who knows a lot about this. And you start with your HR department, and maybe somebody, maybe a lawyer, but I think starting with HR is a good idea. So to get a reasonable accommodation, the employee must inform the employer of the need for an accommodation, and then that triggers an interactive process, which that's the primary protection I think afforded by the primary mechanism to provide people protection is this process. It's not a specific protection like time off or anything. It's just this process that I think people ultimately are insured, that refers to the information gathering and sort of the good faith effort to see how to help the person with a disability. So of course there are limits to what a reasonable accommodation is, and that is whether or not the limitation would cause undue hardship for the employer. And I've defined that. I have the definition here. So another limitation is that with or without an accommodation, the employee must still be able to perform the essential functions of the position. So for example, if an employee cannot meet the production goals of a position, even with an accommodation, he or she may not be protected by the ADA. Factors regarding whether a job function is essential or not are listed here. These are hard to apply. So again, case-by-case assessment. I think some examples might help. These are the easy examples, right? So an essential function of being a pilot is to be able to fly a plane. So if the accommodation can't be that this person shouldn't have to fly, that's what they were hired to do. Or another example is a person who was hired to keyboard documents. The ability to keyboard accurately is an essential function because this is the reason that this position exists. So there's a pathway if the accommodations are denied, and file a charge of discrimination with the EEOC. There may be, like I said, there may be state or local laws in addition, but you can't file a suit until this goes through the EEOC or the state agencies. So yeah, for employers with fewer than 15 employees, this is probably a state matter. Okay, so we're going to move on to anticipating disability. I already at the beginning explained how I feel about that. So I'll leave it at that. So we'll talk about ERISA claims, right? So that's access to employer provided disability policies. It's very important because most, like I said before, most people with a condition like multiple sclerosis will not be able to go out into the marketplace and get disability insurance. Their best bet is probably to get it through an employer. But there may be some people who are at high risk for a disease. And I think Huntington's disease provides a very clear case of this. And I actually haven't spoken with someone who has whose dad had Huntington's disease. And she was thinking about getting tested. And I suggested that she get a lot of disability insurance before she got tested for the gene. And she had a 50% chance of having the gene that would predict with certainty that she would get Huntington's disease. So there are rare situations when people are at risk for a chronic disease and they may be able to get private disability insurance before getting diagnosed or treated for the condition. And MS, I don't think really generally applies here. There may be some people who have families with multiple affected first-degree relatives, and maybe in that situation, before you find out if you have MS, you might consider getting disability insurance, but that's a pretty rare situation. For the most part, people with MS will be getting their disability insurance through work. And these policies, like I said, usually pay 50 or 60% of a worker's salary. Sometimes an employer will provide an opportunity to increase coverage for employees who are willing to pay for it. Workers with MS or other chronic diseases, at least in my opinion, if they can afford it at all, should strongly consider the additional coverage. And then what about pre-existing conditions? What if you have MS and you start working somewhere and you get disability insurance? Well, that would be excluded as a pre-existing condition for a period of time. And it makes sense if you think about it. If you get a job somewhere and then the next day, get disability insurance, and the next day you say, oh, I have MS, I can't do this job, that would be obviously unfair, and there would be a pre-existing condition and it wouldn't work to seek disability benefits at that point. But if you can make it for a year, and then the pre-existing condition generally will not prevent a claim related to, in this instance, multiple sclerosis. And just a note of caution is that if you do take leave during that year, like under the FMLA or otherwise, that would not be counted as part of the 12 months that would need to be worked to allow someone to file a claim for disability benefits successfully. And then you should know a little bit about if you do work for a company that has private disability benefits, it's a good idea to understand some of the basics about how they work. There are let's say three different kinds of policies. There's an own occupation policy, and then there's an any occupation policy, and then there's a hybrid policy, right? So the any occupation policies require you to be unable to perform let me start with the own occupation. So an own occupation policy is one that will protect you if you become unable to do your own job. So my example here is a neurosurgeon who develops a very slight tremor would be protected by an own occupation policy. And any occupation policy might not protect the surgeon because the surgeon was able to do some other job. And most plans are hybrid policies. They begin with an own occupation policy, and then for a period of time, such as 2 years, it remains that way, and then it changes to an any occupation policy. And right, that's the jargon, is own oc or any oc, but of course it refers to own occupation or any occupation. So it's a good idea to become familiar with the specific protections that you have in your policy. So many private disability benefits, private disability policies, actually every one I've ever seen, requires that the insured person, as a condition of continued receipt of benefits, must apply for Social Security disability benefits. And that there are different standards for Social Security, which is closer to that any occupation standard than the own occupation standard. So it's possible that you're disabled for purposes of your private disability policy, but not your Social Security disability policy, or Social Security, not for purposes of the Social Security Administration. And the, again, good thing to know about your policy is your private disability policy is there probably is an offset for Social Security if you do get Social Security disability benefits. So if, let's say, you receive $3,000 a month from a private disability company, and then you begin to get $2,000 a month from Social Security, the long-term disability company will stop paying you $3,000, will begin to pay you $1,000, which is the difference between what they owed you and what Social Security began to pay you. So the point is, I guess, that Social Security disability insurance will not, if you're getting long-term disability benefits, Social Security disability insurance will not augment the amount that you get. It won't change. It will just become an offset to your long-term disability company. And so, but it's still important to apply for Social Security. Again, assuming you're getting long-term disability benefits, you need to, as a condition of continued receipt, you'll need to apply for a Social Security disability insurance, as I mentioned, but it's in your interest to do so, even though you won't get more money in the for the life of the private disability policy. But there are other reasons that you care, and that is that with Social Security, you're entitled to Medicare 30 months after your disability began. And then there's an even more complicated reason that you do care, and that relates to the disability freeze. So this protects your retirement benefits, because most long-term disability policies will only pay out up until age 65 or retirement age, and then you will get Social Security retirement benefits only. And so you care very much that Social Security finds you disabled, because that will create this disability freeze. So Social Security retirement is generally calculated based on the highest inflation-adjusted average of your 35 years of earnings. And so for somebody who becomes disabled at age 40, there'd be a lot of zeros in there from 40 all the way to 65 that would be averaged into your Social Security retirement benefit. And by being found disabled, those zeros will not be factored in the amount that you get at retirement age. Oh, and then if you get long-term disability benefits, a lot of times the long-term disability company will say, oh, please use this company to represent you. And they'll refer you to a group of, usually they're not lawyers, you may think they're lawyers, and I don't think people generally get the best service there. And so I would caution you against using the person that they refer. They say, oh, this is a free service, and for complex reasons, anyone you hire would be free to you if you're getting long-term disability benefits, at least in most situations. So you have the right to choose your own counsel. Okay, so we talked a little bit about Social Security disability insurance already, but So to become eligible for Social Security, there's something known as the 2040 rule, which says that requires that you have earned 20 credits in the prior 40 quarters, which is very difficult to understand. Another way of saying it is generally you need to have worked 5 years in the prior 10 years. So not everybody is protected for purposes of Social Security disability insurance. You need to have a recent work history. But most people who've worked full or even part-time and paid taxes most of their adult lives will be eligible. It's people who have had really kind of intermittent work or haven't worked for the last 5 years that may have a pretty big problem here. And so there are consequences to withdrawing from the workforce that I don't think people think about, and maybe they should. So this is a potential trap for people who, let's say, stay-at-home spouse. If somebody stays at home waiting for their daughter to start first grade, and then they intend to go back to the workforce and have developed some disability at that point and can't, well, they're probably out of luck and they won't be able to apply for Social Security disability insurance. It's relatively easy to maintain eligibility for people who are in that situation. So this is a number that changes every year, but in 2021, someone only needs to earn $5,880 for the entire year to earn 4 credits. So if for people who want to stay home, consider maybe very part-time work. Even earning half of that would get you 2 credits and extend out the protections of Social Security for another period of time, another year. And related to that, you should not delay your Social Security application. Apply for benefits soon after you stop working due to a disability. Again, this relates to that same rule. 5 years after continuing work, you will become uninsured. And while it's possible to apply for disability benefits after 5 years and argue that the disability has been present for a long time or before that 5 years expired, it's much more difficult to prove. And I see this a lot, and I see the sort of stay-at-home spouse problem quite a bit. And then there's another risk that I just wanted to highlight, and that's a risk of transitioning from private to public employer from a private employer to a public employer. So those who work for government agencies and public entities typically pay into, in Colorado, Public Employees Retirement Association, not Social Security. So it's a whole separate system. And if you become disabled, you would apply for disability benefits through PARA. And then, another aspect to that is that people usually pay Medicare taxes, even if they're paying into PARA. And so for somebody who becomes disabled through PARA, they still may need to apply through the Social Security Administration to access their Medicare benefits. But the risk that doesn't happen very often, but it's very hard to watch. So I'm going to mention it. Somebody who's paid into Social Security, let's just assume somebody pays into Social Security and takes a break and then wants to return to work as a public employee. If someone makes this change and becomes disabled shortly afterward, he or she may not be insured through either program. So you can see PARA generally requires 5 years of work to become eligible for disability benefits. And so if you're not paying into Social Security anymore and paying into another system, it may be that you get stuck without any protections at all. So it's hard. It's very if you become disabled and your only protection is Social Security, it can be financially very difficult. And of course, Social Security is critical, and of course I'm thrilled it's there to protect people with MS and other diseases and other disabled people. but it creates quite a hardship for people if that's their only protection. So your best case scenario is to receive money 5 months after you stop working. And essentially, to apply for Social Security, you need to stop working. There's actually more specifically, there's a certain number called substantial, that's sometimes referred to as substantial gainful activity, which is about, I think it's $1,310, but you have per month before taxes. But if you're making more than that, you can't, I mean, your claim will be denied. So people essentially have to stop working, and their best case situation is to receive money 5 months afterwards. And the way they pay it, it's actually 6 months. And very few people can have that, the wherewithal, financial wherewithal to go that long without an income. And worse, most initial claims are denied, 65% of them. And it's even worse for people under 50. And then if an appeal is necessary, you may have to struggle for approximately 18 months without an income. And of course, there's still a risk that the claim might be denied. So it's a very challenging situation. I think it makes just the point is that if possible, have private disability benefits. And most people I see in this situation who do okay are in families, and I guess that's an important point, that the most important safety net of all is family and friends, because again, very few people can make it 18 months without an income on their own. So, things that you can do to improve your chances of being found disabled, should it be necessary to seek disability benefits, will be your medical record. So, as I wrote here, beware, some clinicians don't do disability paperwork. And, I understand their position. They didn't go to medical school, for example, to fill out paperwork for disability, but it's critically important. And I think it's so important that if you're with a clinician who won't do that at all for people, you might have to establish somewhere else. And creating a strong medical record is important. I sometimes tell people that what matters is not the truth of your disability. What matters is the degree to which your disability is reflected in your medical record. So you'll need to keep regular appointments with your medical providers, which of course you should do anyway. But I've certainly come across people who are not interested in the FDA approved medications, for example, who chose not to receive care for MS and wanted to apply for disability. And his claim was a long shot, and he ultimately couldn't prove it because he had no medical record to do so. Social Security may view your failure to seek treatment as an indication that the problem isn't very severe. And then another pitfall is people who rely heavily on telephone or email to communicate with their clinicians, their challenges. The emails and phone calls may wind up being excluded or may not be included in the medical record reviewed by Social Security. This came up for me with a client who was having seizures and would notify his neurologist about his seizures via email, and there was no record of it. And so his claim wound up being denied. He won on appeal, but it made his claim more difficult that he hadn't done office visits and instead chose just to send emails to create his medical record. Another important piece of advice is to follow up on all recommendations made by your clinicians. I've seen non-compliance used to support a denial for long-term disability insurance or Social Security disability insurance. And by LTD, I'm referring to private claims. If you're unable to, if you get referred to physical therapy for your imbalance and you don't, then Social Security might, I think wrongly, but they might, a judge might write that this failure to follow up with physical therapy indicates the problem's not severe, or that maybe if you had gotten treated, it would be better. So if you're unable to follow up on a recommendation, such as maybe you couldn't go to physical therapy for lack of insurance. That would be good to put that in the medical record. And then see all appropriate medical providers. For mental health problems, I think this is particularly important. People often follow up with psychotherapists, people who have master's degrees, and I think that's great for care. But in terms of establishing limitations, it's probably better if those limitations, what you can't do, is in your medical record, and it's the opinion of someone with a PhD, psychologist. And if you have cognitive problems, I think you might wind up being treated by a speech therapist, but it's probably best to have a neuropsychologist do the evaluation. And then, this is probably the most important part of having your medical record support your claim. It's to tell your provider about all of your symptoms and limitations. So the symptoms describe your experience of having an illness, such as fatigue. The limitations are the so what of your symptom. For example, needing to take a 1-hour rest or nap in the middle of the day due to fatigue. So my fatigue is so severe that I need to take breaks throughout the day of at least an hour or more. It's probably insufficient just to say that you have fatigue, because there's no associated limitation. And cognitive problems, again, that's the symptom. The limitation would be an inability to concentrate for more than 5 or 10 minutes at a time, or an inability even to read more than a few pages at a time anymore. So it's a good idea to have those kinds of limitations in your medical record rather than just the symptoms. Include any adaptations in your activities. So this is another real example. It's somebody told their doctor that they went on a skiing vacation, and they didn't point out the limitations of their ski vacation, which turned out to be that she didn't ski. She needed to be moved from the parking lot to the ski lodge in a wheelchair. And it can create the wrong idea that she went skiing. Create a longitudinal record is also important. It's probably more convincing to either the reviewers of your private disability claim or the judges of a Social Security claim if the medical record has a history of challenges in the workplace or symptoms over time, rather than symptoms just being described at the last visit. This is an ongoing process. And if you're having trouble at work, I think it's important to get that documented as soon as it happens. Even if it's mild and no one knows about it but you, it's just maybe you're beginning to take work home because you're not able to keep up with the pace anymore, as an example. Okay, so that is, that's all I'm going to present for now. I just want to thank the Rocky Mountain MS Center for support and the wonderful clients that we've had over the years. And then the people I work with here are listed: Teresa Mitchell, Sarah Darnell, Tori Wampy, Liz Ledchuk. And then with that, maybe I can bring Kelsey back into the conversation and take a few questions.
Yes, thank you so much, Tom. And now we will be moving into the Q&A portion. We did have a number of the questions that were submitted at registration answered already, so thank you guys for great questions. I'm going to bring up a few more that were submitted during registration, but you can continue to put questions into the Q&A box or the chat box, and we will add those to the list. I think you covered this one, but I just want to confirm that if you have to stop working, do employer-provided policies typically end at age 65?
Or I think retirement age. So okay. I think it's 66, 65, yeah, something like that. And it's different for people who are older. So it would be kind of unfair if somebody had been paying disability and paying the disability insurance premiums their whole career, and then had plans to work until 70. And became disabled at age 64, and then was out of luck after 1 year. So the policies usually have a schedule that goes beyond that, beyond retirement age, for older employees.
For para, does the 5 years of work need to be consecutive, or is that another 5 years in the last 10 situation?
Great question, and I don't know the answer. Sorry.
If someone is disabled and has to do part-time work, then after a few years they can't work at all, is their income lessened because they were working part-time?
So, so let's think about it from two perspectives. One is from the perspective of private disability insurance. So if you have the same employer and you're working full-time, then you get 70% of your salary, let's say $50,000, right? So $35,000 a year. If you become disabled, you leave that job and you're working 40 hours a week. But if you then reduce your hours, as I alluded to during the talk, if you reduce your hours to say, let's say 30 hours a week, you may not have benefits anymore. And so then if you become disabled, you wouldn't have any private disability benefits at all. So it's really a challenge for people. You know, you want to applaud people who want to stay in the workforce as long as possible, but it might be financially detrimental to do so. So that's through assuming that's with the same employer and you're just kind of lowering your hours. I think, yeah, you can lower them to such an extent that you get nothing in disability. Now, in terms of Social Security, which maybe is what the question was supposed to be about, is, yeah, it's based on your average earnings over time, so that if you can stay in the workforce and earn less and less over time, you might wind up with a lower benefit. But it's not a cliff, it's an average of the, up to 35 years earlier. So that really sort of dampens the blow of trying to work and earning less in subsequent years. So I don't think earning less in 1 year than the previous year would be very detrimental to the amount of the benefit. But I do think that maybe doing so for 10 years might.
We had several folks who are small business owners question if there's anything particular for self-employed folks to consider.
Yes, thank you. Again, these are great questions. I appreciate it. So I think a lot of times people who are small business owners don't report enough taxes because they have control of that, and they don't pay Social Security taxes sometimes, and because they can, adjust their earnings, and they might wind up unprotected by Social Security if that's done too aggressively. I've seen people who were in that situation, and it is possible to some extent to go back to say, oh, whoops, I underreported. I should have paid more in taxes, and because that would have allowed someone to become eligible or maintain eligibility for Social Security disability insurance. So, I sometimes joke that the only part of our taxes where we get anything is Social Security, but sometimes it is in our interest to pay those taxes. Does that answer that question?
I think so, yeah. I have a couple of questions that I think.
Can I go back?
Yeah.
So if you have a small business, there's one other piece that I've seen that's interesting is if you, again, it's hard if this happens while if someone already has MS, it's hard to see getting a policy, but that protects you against disability. But if, let's say you did it before diagnosis, it probably makes sense to pay for it, not through the business, as tempting as that is, because if you buy it with your after-tax dollars, not through your business, then the money that you get will be tax-free. And I've seen that a couple of times. It's a pretty nice benefit when that happens. Sorry, Kelsey.
No, that's great. We have a couple of example situation questions. people are wondering if they are having trouble being negatively impacted by their MS at work. I think it's a reasonable accommodation type question. What kind of suggestions would be if someone, one person was off on their cash drawer at the end of the day and they've requested to be further trained, the supervisor denies that request. And then also another similar question of if you're being negatively impacted at your job and you can no longer do your specific job, is it your employer's responsibility under the ADA to help you find a new position? Or do they have to keep the same pay rate if the new position is a lower paying job?
So help me remember the first one. I think they're different enough. Thanks. Okay,
Yeah.
Kelsey. So regarding the second question, so the finding a new position is part of the ADA. It's sort of the accommodation of last resort, though. So there should be, the employer doesn't have a responsibility until the employer knows that you are in need of accommodations. And then once that happens, that starts this process that I mentioned. And then all efforts should be focused on trying to allow somebody to stay in their current position. But then if not, then yes, they're to look for other positions that they can do, but no, not at the same salary if it's a job that doesn't generally command the same salary. And I hope that answers that question. And and again, for these kind of specific ones, I really recommend that you, call the Job Action Network, JAN, that I mentioned earlier. It's a really rich resource, and you can even fool around on the web and look up things like regarding, again, that first question about what do you do with like decreased attention, and they have some very practical solutions, none that are going to fix someone's attention, but that's where I would call there if you have specific reasonable accommodation questions. But yeah, so for somebody who's off on their cash drawer, yeah, that would be concerning, right? And I'm sure that an employer would not tolerate that too many times. So this is kind of what I was talking about. If you do have a large employer, let's say you're protected by the FMLA, this is maybe a good time to take a pause and to explore your options. So go out on this, maybe talk with your clinician and see if you can go out on leave for a month to look at rehabilitation efforts through your clinic. Can you get referred for neuropsychological evaluation to document that you do have or not cognitive problems, and then what might be done to improve them. Treating sleep apnea would be an unlikely example, but possible, right? So maybe it's something that can get improved. Physical therapy might be good. And then most of all, maybe time to reflect on whether that's a job you can do by talking to friends, family, clinicians, especially the neuropsychologists, if you can arrange that. And then time to research your protections. Do you have private disability benefits? And to what extent would it pay you, and for how long? So, and think about whether that might not be the right answer, is to apply for disability benefits versus trying to fix things at work and trying to find an accommodation. I hope that helps. That's a hard question.
I think they're all hard questions. We did have a couple of questions that seemed pretty specific about reasonable accommodations. So I'm just going to echo your suggestion to reach out to the Job Accommodation Network for those answers. In the interest of time, we're running low, so I want to make sure we hit some of these other topics. If you have employer provided coverage and need to stop work due to a disability, how long after leaving the job will you be able to make the claim? And do you need to make the claim before you leave the job?
Right. So you're certainly better off doing so. To make it as soon as possible, preferably while you still have a job. I've seen, I think the first place to look is in the policy. It's going to be variable. I saw somebody in the clinic who had not worked for 6 months, and it was, he didn't realize he had cognitive problems, and it was hard to see him kind of that dawn on him, and that's why he didn't have that job. So so I suggested that he apply, and he wound up getting disability benefits. And in that case, maybe it was longer than 6 months, I don't remember, but it was less than a year. The policy said that if for people who apply late, they're going to get a reduction in their benefits. So instead of getting 60%, maybe it's 50%. I don't remember what the numbers were. And then we actually appealed that and said, oh, this is because of my cognitive problems that I didn't apply when I was supposed to. Essentially was the argument. Not that, I'm not sure it was even an argument, because there was nothing in the policy that said, oh, unless it's due to your symptoms. But I've never seen this before, but they said, okay, and they paid them the full 60%. So the answer is definitely apply. I think it happens more often than it should, is that people don't connect their symptoms to having to leave a job. Maybe they were fired and it's sort of feels bad. And there's a lot of anger. It's a very emotional experience. And I think sometimes people can't see that their symptoms were involved in how they got fired, and that maybe they should have applied for benefits. So the earlier the better, but I would always apply. Now, if you've taken another job, then I think that would prevent recovery. But if you haven't been able to work again, and it's continuous, again, good relationship with your clinicians, you're going to have that kind of support to say that, yeah, this disability, we got neuropsych testing done six months after you stopped working, but these symptoms don't develop overnight. Undoubtedly, these symptoms have been present for 6 months, and very likely are the reason that he didn't apply for disability benefits in the first place. So yeah, that's a long answer, but it's a great question. It comes up much more often than you would think it would, that people just don't apply for disability benefits.
We did have a couple of questions as well, with folks wondering, I'm newly diagnosed, or I've been out of the workforce due to a disability, but I'm doing better on treatment now, so I'm able to go back. How do I address that in an interview? When do I disclose to an employer? Do I tell them in an interview?
My opinion is no, that you shouldn't say you have MS or whatever other disease that it could be at an interview. If you can do the job, and then if they need to make accommodations for you, then that's what they need to do. At that point, you'll need to, of course, disclose, or if you want the protections of the FMLA, you'll have to disclose. But I don't see any reason to ordinarily, outside of seeking protection under those laws.
So what would be some key points for folks to consider telling their employer when they should start thinking about that for themselves?
Like I said, I think let's say it becomes obvious. Let's say an employer starts to notice that your pace is off, or your gait is obviously not normal. I've heard patients or clients say, oh, people think I'm drunk at work. Well, that's not okay, right? So maybe if people notice that something's wrong, that might be a time, certainly when you're seeking the protections of the FMLA. If you're starting to be absent a lot, that's when you disclose. But I guess I'm saying the same thing. I'm not sure if there was a different question that I missed there, though. If so, sorry.
No, I think that's good. We also I want to let everyone know we have an issue of our Informs magazine on mscenter.org that covers the issue of disclosure. It's got several good articles and interviews in it. So I would recommend checking out that issue. If you would like a direct link to that, you can email me, which is education@mscenter.org, and I will send you out the direct link to that issue. We have one person planning ahead for the day that they might need long-term care. Does SSDI pay for something like that?
No. So states have various Medicaid programs. One of them in Colorado, it's known as long-term care Medicaid. It's different from adult Medicaid. There are very strict financial rules and rules regarding loss of independence. So for people who are severely affected, more severely affected, relatively more severely affected than not being able to work, not being able to live independently, there is a government payer for that. That's Medicaid. But they're very strict financial rules, and if you have more than $2,000, you won't qualify. So there are various ways to deal with that, such as trusts or spending down your money, using your money until you don't have money and then qualifying for Medicaid. And then there are private long-term care policies, but I think they'd be pretty hard to get for someone with MS unless they were obtained prior to the diagnosis.
We have a newly relevant question about someone left their job due to an increased risk of COVID exposure because they're immunosuppressed. So the job had the COVID risk, not it wasn't their MS symptoms directly that caused them to leave, but they can't go back to work in their field because of the risk of COVID exposure. Is that a reason to be covered for disability?
This isn't a great answer. I would certainly make the argument for private disability benefits that is why you're no longer working, because immunosuppression was medically necessary, and the job is high risk for somebody who's immunosuppressed, and maybe you can get your doctor to say, I don't want you to be working around other people, or if it's a healthcare provider, I don't want you to work around other taking care of infected people. I think that might work. So far, I've seen Social Security pretty reluctant to accept that as a reason for disability. Part of their argument is that you need to have continuous disability for 12 months. But so far, Social Security, I don't think is buying that, but I think it could work with a private disability company potentially.
Awesome, and we are actually over time, so I will just have one more question for you, Tom. How you mentioned that representation to file a disability claim is free to folks, generally free to folks. How would you recommend people go about looking for someone to help them with a disability claim or consult with someone? What pointers do you have there?
Well, just to be clear, getting representation for a Social Security claim is not free in general. It winds up being free if you have private disability benefits that you're receiving while when you apply for Social Security disability, because any money you get from Social Security, in many cases, would go back to the insurance company as an offset. So the money you get from Social Security is not really yours. And if there is a piece for representation that comes out of that, it's really the insurance company that's paying for it. That's what I mean by it's free. It's free only in that circumstance. Okay. So,
generally speaking, yeah, folks have more complicated questions or want to speak to someone one-on-one.
Right, and I'm always happy to talk with people, and I don't charge to consult with people if you have questions, especially about disability. I'm happy, please call. I don't have the number handy, and maybe I should. Let me see if I can find it real quick.
We'll include that in the follow-up email as well, so everyone will have it. Mm-hmm. Awesome. So everyone who signed up for today's webinar will get a copy of the recording sent to you. We will archive it on mscenter.org and YouTube. Please make sure that you're signed up for our mailing list. That is how we announce notifications about additional upcoming educational programming. So thanks everyone for your great questions. Thank you, Tom, for your time and your expertise, and have a great day.
Okay, sure. Bye. Thank you.